I welcome you all on this occasion of seminar organized by Bombay Lawyers Association today. And request the president of this seminar, Barrister L.C. Chogle, to deliver his presidential address.
Ladies and gentlemen, we have met this day for a seminar to discuss the important topic, namely RTI Act in practice and Supreme Court judgment, problems and prospects. It is an important subject because it sets out to discuss, analyze and study a burning topic of the day, the right to information, which is very necessary and vital in the modern day life. We all ask, what ails the body politic, the knight at arms today? Indeed, we live in times of great perplexities and are beset with problems of health, social, political, financial, socio-economic, agricultural, irrigation, etc., etc. There are manifold problems, innumerable problems, and of unlimited duration. It is the lack of transparency and integrity that prompted Parliament to enact the Freedom of Information Act of 2002, which having been found wanting in several respects, it was replaced by a more comprehensive Right to Information Act 2005. That is the act we have come here to discuss, analyze and study. It is the Civil Services Conduct Rules, you remember, and the Manual of the Office Procedure, as well as the Official Secrets Act of 1923, and also the mindset of the British governors and officials of those times, which were treated as an implied impediments to the full and complete and purposeful achievement of the object for enacting the Act of 2002. But this Act of 2002 had several infirmities. What was required and expected to meet the aspirations of the citizens of India, the Act could not deliver. But we are worried, we are agitated that so many lakhs of crores of our money is being wasted, tainted by dishonest people. We have a right to complain indeed in this regard, and that is why we have the gift from Parliament, namely the Right to Information Act 2005. Now, towards this object, the right to information is a valuable tool in our hands. This right is not expressly stated, as I said, in the fundamental rights, but is covered by the right to expression, speech and expression. It's a valuable tool in the hands of any citizen to keep in check and balance the unlawful desires of corrupt officials. With this bird's eye view, I don't want to take more of your time because you are all very anxious, very eagerly awaiting for the enlightening speeches of our eminent illustrious speakers this evening, who will enlighten our minds more on the subject. It has practical problems and it has its own prospects, and we are all awaiting the illuminating speeches of the speakers. To begin with, and to set the ball rolling, I may request our beloved judge of our own High Court, Justice A.P. Shah, the retired Chief Justice of the Delhi High Court. Mr. Justice Shah.
Thank you. My speech shall be divided into three parts. Key features of the Act, because unless you understand the key features of the Act or the important provisions of the Act, you will not be able to understand the judgment of the Supreme Court. The second part is critique of the Supreme Court judgment, and the third part is desirability of having the Information Commission manned by judges. These are the three aspects which I would like to cover today. Let us see the provisions of the Act.